Good afternoon and welcome back, everybody, to our second part of creditor protection and asset protection trusts. We'll move on to the age-old question of, can I protect my assets by putting them into a trust? The answer is no, yes, maybe, sometimes, and it depends. But we're going to answer all of those questions and get to all of those specific answers themselves through today's presentation, which is part two of our asset protection series. Today, we will be covering trusts for asset protection. A few things before we begin. Even though I think this is great information, someone decided that this is attorney advertising. It wasn't me. I think this is just great information for everybody to have. However, once you see the disclaimer of attorney advertising, you cannot unsee it. And that's me from a few years ago in the corner picture on the bottom right-hand side. Before we begin, I do want to thank Whitney Robinson, paralegal extraordinaire, and Nacy Lopez, attorney Esquire extraordinaire, for their help as well with this presentation and the last one for that fact. I couldn't pull these off without them. This is a team effort. Now, today's table of contents will be as follows. We're going to talk about real estate limits on creditor protection. Real estate is special. You know your home is special. Well, it's special for creditor protection in ways that you may not like. We'll then move on to using standard, revocable, and irrevocable trusts within your home state. Looking at irrevocable trusts in other states of the union. And last but not least, we will discuss offshore, meaning outside of the United States trusts as well. Each of these has some level of creditor protection for 2, 3, and 4, but they differ and they tend to increase in protection the further you go down the list. Before we get to our first chapter, let's have a brief refresher. Number one is, what is a fraudulent conveyance? Well, that's when I give something to somebody else, whether or not I intend to confound a creditor. So I give my son, Timmy Timins, $100,000 after he gets married because he wants to start a family and he wants a down payment for a house. And I say, Timmy, just as a gift, you don't have to do anything to get this. I'm just being nice and I'm giving you $100,000. Well, if someone sues me because I hit them with my car, they can look at that $100,000 gift I made, as long as it was within the last 4 years, and say, Dan, you gave this money to someone else and you didn't get any services in return. You just gave a gift. That's right. They can say that I gave that money without the intent to defraud them here in most states and still try to get it back from Timmy. The idea of a fraudulent conveyance is I give a gift, whether or not I intended to give that gift to confound a creditor, and my creditor can get that money back. I have to give that money, that gift, more than 4 years ago. We're looking primarily at New York. New York has a 4-year fraudulent conveyance statute, as do many United States. The second refresher is types of creditors. Not all creditors are created equally. There are your super creditors, the IRS. I can't confound the IRS very easily, right? We went over that last time. The IRS can get their hands on just about any type of asset that I have, except for offshore trusts. But there are caveats. We also talk about things like spouses and child support, very hard to confound super creditors, federal crimes. Then there's statutory creditors, people who paid your funeral expenses. We don't want your body sitting on the street. So there are laws that say when you get buried, the first person who gets paid is going to be the person who helped to pay for your burial or funeral expenses. And then student loans have a lot of caveats. We then have secured creditors like your bank that extended you a mortgage on your home. It's secured because they can collect your home back if you default. Now, if your home is underwater, in other words, there's a mortgage for $1 million and they only sell your home for $800,000, well, they are secured for the first $800,000. The remaining $200,000, they are not a secured creditor. And that's the most important part of what we're discussing today. Who are your unsecured creditors? The people who file lawsuits against you. I hit you with my car, right? Or we get into a fist fight and they found that I was the one who started the fight and I hurt you bad enough. Becomes increasingly unlikely as I hit my 50s. Credit card debts. There's nothing for them to place a lien against directly, right? They're not secured. They have to place a lien against you personally. Medical bills, like we said, they don't want your sutures back if you don't pay your medical bill. They want to get money from you. They don't have any direct collateral that they can securely take back from you. We call them unsecured creditors. Those are the ones that we are talking primarily about today. Now, first things first, real estate. It's tough for you to protect your real estate in one state if you try to transfer it to a trust that's governed by the laws of another state. Why? Well, because your real estate in your state is governed by your trust. By way of illustration, I'm here in New York. Well, if I live in New York says, hey, the land in New York is our land here in New York. You can't just take our land and say we're going to have the land in this state controlled by the laws in another state. Like if I'm in New York, I guess I could shovel the dirt over the border into New Jersey, but as the crow flies, as the satellite goes, as far as the state is concerned, that actual patch of land in its state is still here in New York. Out of state trusts do not protect my land in the state in which I'm located in. Here's the hypothetical example. I transfer my New York home and the deed of my New York home into a Nevada trust. Nevada trusts have some favorable creditor protections. So now the deed to my home is owned in a Nevada trust. Someone sues me. Again, the fist fight Dan gets into, and I injure them somehow, and they say, Dan, I'm going to sue you. Well, because my home is located in New York, and New York ignores any creditor protection from any state that has favorable creditor protection because the actual land is here in New York, the person who's suing me gets to get at my home because New York does not have favorable creditor protection over real estate. And they will ignore the laws of the state of Nevada, even though my home is owned by a Nevada trust because the land is here in New York. Keep that in mind. Your real estate doesn't get protection from out of state trusts. Now, we went over tenants by the entirety last time. You know, if you own your home with your spouse jointly, it's called tenants by the entirety. And there is some protection if the spouse who's not the debtor owns the house and survives the debtor. Check out part one for more on tenants by the entirety. Secondly, if I transferred the home out of my name at least 4 years ago or more, it's protected, right? But it's got to be transferred out of my name and I can't have any control over it. So again, real estate isn't protected from out of state or out of country offshore trusts. Now, how do we use revocable and standard in-state irrevocable trusts? Revocable trusts never protect the trust creator, right? Irrevocable trusts may, as long as I don't have ownership and control over the irrevocable trust. What do we mean? So standard trust, I'll give you the example again for New York. Revocable trust, the left-hand side, right? There's no creditor protection if I create the trust for my benefit. If I can revoke the trust, it's my alter ego. The law says, we could still take this home from Dan. It only protects my future beneficiaries. So I will create what is called in my revocable trust spendthrift provisions for potentially, let's say, my children or my future beneficiaries. Now, because the home is mine, I get no creditor protection, but it does get creditor protection from my children's creditors. And it doesn't just need to be my home. It could be my investments. Anything owned in my revocable trust when I die, if it goes to Timmy, can be protected from Timmy's creditors. Not my job to pay Timmy's creditors, with some limitations. If Timmy is the sole trustee, if he has the ability to distribute all of the money whenever he wants, or if he can choose the successor trustee whenever he wants, he's going to get limitations on that creditor protection. We don't like limits. We want the whole creditor protection, right? Now, the good news is this: if I transfer my property to my revocable trust, and then someone says, Timmy, hey, you tried to transfer property into your dad's revocable trust, and we're going to get you for a fraudulent conveyance. That's not how that works. It was my property going into the trust. So if I transfer my property into a revocable trust, Timmy doesn't get in trouble for a fraudulent conveyance. I might, but not Timmy if I transferred my property into my trust and then I die. So keep that in mind. Revocable trusts, great for beneficiaries if we put limitations, not so great for me, the trust creator. For all of the trust on the right hand we are going to be talking about are going to be irrevocable trusts then when I place property into my trust. Well, my trust has to be irrevocable. It will be either a spousal lifetime access trust, which we'll talk about in a few moments, out of state trusts, or overseas trusts. All of those trusts are irrevocable. So we got it. Revocable trusts don't protect me, they protect future generations. Now, if I trust my children and I want them to be named as the trustee when I die, they get no creditor protection unless I limit their access to the trust to health, education, maintenance, and support. People see this, what we call HEMS standard, and they don't understand what it means. My children's HEMS are kind of their basic living expenses. If I allow my child to take out for healthcare, it doesn't include plastic surgery or hair transplants, right? Unless it's necessary for their health. But if I limit my child to being the trustee and they're the beneficiary of my trust, and I say I limit you to education expenses, they want to go to college, that's considered a basic living expense. Maintenance and support doesn't mean my son can go out and buy a Bugatti. My daughter can't go out and buy a shopping mall. But if I say for their basic, subsistence, food, nothing crazy, perhaps their real estate taxes, that's just fine. So here's the hypothetical, right? Judy names Dan, her son, to act as trustee of Judy's trust. Judy's the parent. When Judy dies, when Judy, Dan's mother, does die, Dan is the trustee and the beneficiary of the trust. This is Judy's money, not Dan's money still. If the trust says that Dan can only withdraw funds for himself for his health, education, maintenance, and support, Dan's creditors, not super creditors, but creditors like his lawsuits or creditors like his soon to be ex spouse, cannot collect the funds from the trust. Because Dan is limited to HEMS, there's creditor protection from his mother's trust when his mother dies, because the money isn't Dan's until it leaves the trust. And Dan can only give money to himself for health, education, maintenance, and support. So the tip here is if you have a revocable trust and you're creating it and you want creditor protection for your children, only allow a disinterested trustee, someone who's not the beneficiary, the ability to distribute funds to your children for any purpose, right? Creditor protection requires a disinterested trustee. If the trustee happens to be a beneficiary and they're not limited to HEMS, bad, bad, bad. No creditor protection. Now we move to Medicaid trusts. Medicaid trusts are great because they can protect the parent who's creating this trust to protect themselves and get onto Medicaid, so the government will pay for their care. It protects the parent's income interest in the Medicaid trust, which is what the Medicaid trust does. It only allows the parent to get income, and it can protect the child from the child's creditors as well. Now, again, the Medicaid protection is for the parent's long-term care. I need the government to pay for me if I get dementia or if I can't, use the bathroom, if I need help feeding, if I need myself help transferring from my bed into the living room, then I can protect my assets from my Medicaid creditors, right? If you have money, you can't just get on Medicaid. You have to transfer assets to Medicaid trusts to protect them so you could qualify for the government to pay for home health aides or the nursing home. Now, I have to meet that look back period, which we discussed a bit last time. And if you want to look at any Medicaid discussions, feel free to look at the website and other webinars I put on regarding Medicaid look back periods. It also protects the child from the child's creditors because the money in the Medicaid trust is not the child's, it's the parent's money when they try to qualify for Medicaid. However, the child can't just distribute to themselves for any reason. Like we said on the last slide, if the child can only have major funds principal distributed to them by a disinterested trustee, like your best friend, your accountant, the homeless person on the street, no one who is the beneficiary or is very close to the beneficiary, like the beneficiary's spouse, then it protects the child from their creditors as well. Now, it protects against the parents and the child's creditors as well if the parent or even the child contributes money to the trust at least 4 years ago. It avoids a fraudulent conveyance, not just for Medicaid, but for other creditors' purposes. That's right. So I could qualify for Medicaid, but it still may be considered a fraudulent conveyance if I'm not protecting myself from Medicaid, but from Susan who's trying to sue me. So fraudulent conveyance can apply also to Medicaid trusts. So you got to make sure that the funds are transferred at least 4 years ago. And for nursing home Medicaid, it's 5 years for Medicaid purposes anyway, for nursing home. So, there's a few things you might be worried about for creditor protection, but Medicaid trust can protect your assets for multiple purposes. Now, there's one warning. If I state in the trust that the parent is allowed to get income under all circumstances, they're required to get the income, then a creditor could hoover up the income interest in its entirety. So it's important with some people that the Medicaid trusts say the parents can only get trust income if the trustee has control over the income and the trustee gives it to them. So keep that in mind with Medicaid trusts. Next, this is how a lot of people use in-state trusts to protect their funds from their creditors. We create what is called a SLAT, which is an acronym. Attorneys love acronyms, called a Spousal Lifetime Access Trust. I, the spouse, am going to allow my other spouse, my wife in this case, the ability to have her lifetime access to funds in the trust. This is how it works. It is a spendthrift trust, protects the funds in trust where I, Dan, for example, leave money to my spouse. I leave it in trust so that my creditors can't get at it, but I'll allow my spouse to get access to the funds with an outside trustee. So if the trust is a discretionary trust, meaning that the spouse's friend or the spouse's accountant or the homeless person on the street is a trustee and not the spouse, a creditor can't force the trustee to distribute funds to the creditor. So I create money, give it to the trust. I have this outside party be the trustee, and they can give funds to my spouse. So the donor spouse, in this case, may be able to access the funds indirectly by telling their spouse, hey, why don't you use this money for you and for me? So here's our hypothetical. Let's say we have Tom. Tom is scared of his creditors. So Tom owns a business and he's an architect and Tom has the money. So Tom is the donor spouse. He has the funds and he's super busy. He rushes his projects. And his wife, Marie, is worried Tom is going to get sued because one of his buildings is going to fall down. He's just too busy to put great time into the blueprints. And Marie says, "Hey, Tom, your professional recklessness is going to cause us to lose all of our money." So Marie tells Tom, "Hey, I want you to create a spousal lifetime access trust that allows the spouse, Marie, to receive funds." And Marie's friend, Alexandra, is the trustee. Tom transfers $1 million to the Spousal Lifetime Access Trust, and the trustee states Alex can give Marie trust funds at any time Alex wants to. Alex is Marie's friend. And Marie can tell Alex, "Hey, you want to give me money right now? I got to go on a vacation." And Alex says, "No problem," and distributes $20,000 from the trust to Marie. And Marie then buys plane tickets and then buys, let's say the hotel rooms and prepaid meals, whatever. And Marie and her spouse, Tom, who gave money to the trust in the first place, can now go on vacation together or other purposes just to live. So a spousal lifetime access trust is a great trust if you trust your spouse and you trust your spouse's trustee. Now, here's the problem for a slap, right? What happens if Tom and Tom and Marie are getting divorced? Or what happens if Marie dies, right? Marie dies, Tom no longer has access to those funds because Alex could only give money to the spouse. Remember, it's a spousal lifetime access trust. Now, I can protect, a client such as Tom if Marie's getting divorced from Tom by putting what's called a floating spouse clause in there, where Tom states in the trust, "Hey, if we get divorced, the trust stops and it goes to our children instead of, Marie, you know? So I can protect the divorced spouse. Or if Marie dies, Tom can still have what's called a limited power of appointment, or even if he is alive but is getting divorced. So we give an outside party a power of appointment, the power to give the funds back to Tom. Here's our example. Marie now says, "Tom, you're too reckless and I don't like you anyway. I'm getting a divorce from you." And she tells Alex, "Hey, I want you to keep giving money from the trust to me, right? It's a spousal lifetime access trust. I'm the beneficiary. Give money." But Tom's attorney was smart. Tom's attorney included in the trust the ability for Tom's friend John, who, again, not a beneficiary, Tom's good buddy, to give the funds back to whoever in Tom's family John wants to give them to, including Tom. We call that a limited power of appointment. John can give money to someone other than himself. It's a class of people that include Tom's family, including Tom. Well, guess what? During or after the divorce, John can empty out the spousal lifetime access trust and give the funds back to Tom. So a spousal lifetime access trust can indirectly give the donor spouse protection and access through the Tom's spouse and still be able to get the money back if an outside party gives the money back to Tom with a limited power of appointment. That's great. We can also disclaim assets as an asset protection tool in some states. A disclaimer or disclaiming says that a beneficiary says, "I don't want the money. So I'm going to pretend I predeceased, my children for the sake of legal purposes." What does this mean? Well, let's say Dan's father, Bob, leaves money to Dan when Bob dies. And it says if Dan dies, Bob's funds go to instead Dan's children, not to Dan, right? When Bob does die and Dan has a whole bunch of creditors, Dan files paperwork with the court that says, "I'm going to pretend I didn't live," right? And instead, Bob's will or trust says then these funds go to Dan's children, right? Survivorship. Well, Dan files this disclaimer with the court because he wants to avoid his creditors getting after him, and the funds then go to Dan's children. I avoid my creditors getting the money, and the funds go to my kids, and I hope my kids are nice enough to spend some money on me someday. Now, there are exceptions in New York. For Medicaid, if I'm on Medicaid and my aunt or uncle leaves me money, and it's in my name, it's not in the name of a Medicaid trust or a supplemental needs trust, I'm in trouble because I'm only allowed in New York to have $33,000 in my name. This happens all the time. If you have disabled family members or you know you have disabled family members who are going to be beneficiaries of someone, you got to tell those people to leave the funds to a Medicaid compliant trust like a supplemental needs trust because otherwise they get booted off of Medicaid. So as far as creditors go, Medicaid is a bad creditor. If funds get left to you and you're on Medicaid, you can't disclaim them to another family member and then hope to stay on Medicaid. And next, this is the problem. New York says, well, if Dan was a solvent person, he can't disclaim away from his creditors. Who else is going to disclaim, right? If I'm insolvent, I want the money. That's the whole idea. I'm trying to disclaim because I have funds. I don't want creditors to go to it. So again, disclaiming can be used as a tool, but it has its limitations. Well, let's get to what everyone came here for. States and offshore trusts. We have to remember all of these trusts are irrevocable. When I create the trust, I can't change the trust. Maybe somebody else can, but I can't, right? Not all states are created equal when it comes to asset protection. There are 19 or 20 asset protection trust states. I'm going to give you two in detail and three others that are notable mentions. First one, the original, the OG of trust, the original gangster trust state was Delaware. Delaware trusts have a few requirements. To protect yourself from creditors, the trustee must be a Delaware resident or corporation authorized to conduct trust business in Delaware. Why? Well, all these asset protection trust states, you're going to see they're states with like 10 people in them. And they're all going to be countries, which are super small countries. And they're trying to say, we want some high blue collared or white collared employees here to get paid some money, right? So Delaware's saying we have like 20 people in the state. Let's have five of them be white collar professionals who get paid, and we'll make sure that we are having these people as trustees in our state get paid good money. So here, Delaware trusts, you have to maintain some of the trust property in Delaware. You have to have like an asset manager in Delaware and the trustee in Delaware. Trust creator, when you create the trust, you cannot be a co-trustee. So you're relying on this Delaware trustee, right? This person or this corporation in Delaware, you're going to have to trust them and pay them every year, right? We're trying to pay these people in these small states who are white collar workers. However, here's some good news. The trust creator, while they can't be a trustee, may consent to investment changes. They say, this is what I want you to invest in. The trustee says, well, I prefer to invest in this. And the creator could say, nope, I want you to invest in this instead. They can say, I don't want you, trustee, to distribute funds to my children right now or myself. That's a pretty good power. Number three, they can replace the trustee or advisors, financial advisors. That's right. Trustee isn't doing what you want in your trust that you can't create. Get a new trustee. You can reacquire trust assets. Well, I invested in something in the trust and it appreciated like crazy. Well, when I die, I want to step up in cost basis. I can swap out assets, right? And retain the right to income. I can still get income from the trust. Hooray, hooray. And I retain what is called a general power of appointment. This doesn't make a lot of sense. I can choose who gets the money either when I die or when I'm alive. I can change the beneficiaries of the trust. I can even change the trust to give the money back to myself. That's a pretty good deal, right? It's almost like a farce, but it's okay in Delaware. I create this irrevocable trust. I pay some guy to be my trustee or girl or corporation. Maybe I pay a financial planner to deal with that down there. And 10 years later, when I'm no longer worried, I'm not worried about access protection anymore because I'm out of my crazy job as a surgeon or as, an architect. I can now give the money back to me when I want, not like a slat where I have to have a friend do it. I get to do that. That sounds pretty good to me. If I'm working a job and I'm scared of being sued, set up a Delaware trust. 10, 20 years later, when I retire, I give the money back to me. Now, Delaware trust creditor protections. Again, they have a 4-year statute of limitations. So if I have a creditor from before the trust was created and it hasn't been 4 years yet, that creditor also must prove that I transferred funds to this trust within this 4-year period and I intended to defraud them under clear and convincing evidence. It's hard to prove. I mean, like, of course, I transferred the funds to a Delaware trust. Like, someone sues me, and 2 years in the lawsuit, I create a Delaware trust and I transfer the funds in the Delaware trust. Well, it's within the 4 years, so it's a fraudulent conveyance. But that creditor also has to prove that I intended to fraudulently take money from the lawsuit. Again, I clearly did it, but they have to prove it. What a pain in the neck. Now, again, what happens if I created the trust and then I got sued? They have to prove that I had the intent to defraud the creditors, right? So I didn't just do this to hinder or delay them. I intended to defraud them. That takes more work from their attorney. That's great news. Now, again, the problem with Delaware trusts, just like other trusts in all United States, I'll say that straight up, is it doesn't protect you from the IRS. It also doesn't, at least in Delaware, protect you from alimony or child support. So again, hard to shake all those super creditors, but again, it's a little different state to state, as you will see. The next is Nevada. A lot of people consider Nevada to be the number one or number two domestic asset protection trust states. We call it a Nevada Asset Protection Trust. At least one trustee may be, or must be, excuse me, a Nevada resident bank or trust company, but the creator of the trust can be a co-trustee. So unlike Delaware, you can be the co-trustee of your Nevada Asset Protection Trust. Protect yourself from your creditors and still have control over the trust. Trustee must have full discretionary distributions, or may, not must. So I can still distribute money to myself. You can name a trust protector so you can kick around, get rid of the existing trustee who's the Nevada trustee. Now, as opposed to 4 years, Nevada only has a 2-year seasoning period. So not quite a fraudulent conveyance matter, but you can say, I create the trust, I move money into there, and 2 years later, Nevada protects those assets. It's not 4 years, it's 2 years in Nevada. That's great. Now, the trust creator, not only can they be a co-trustee, they can consent to investment changes. They can veto distributions, very similar to Delaware. They retain the right to income, also like Delaware, and they also have a general power of appointment. I'm that person who has or expect to have creditor issues maybe 2 years and additional few months from now. I create a Nevada Asset Protection Trust. And then I wait, and 2 years and 5 months later, someone sues me. And I just say, okay, let's let this trust ride. We finally come to a settlement. I say, look, I'm going to pay them 20 cents, 10 cents on the dollar. They're gone. I can now give the irrevocable trust assets back to me, a general power of appointment. That's a pretty good deal, right? I could intend to defraud my best friend, Billy. I'm going to get Billy. Give me $100,000, Billy. He gives it to me, and I go to Vegas and I lose the money, but I wait 2 years before I spend it at Vegas. And then I stop paying Billy back. Well, he gave me the funds 2 years and a few months ago. He can't get at my assets in the Nevada Asset Protection Trust. Billy finally says after a few years, fine, Dan, you got one over on me. Pay me back $20,000. We'll let this go. Boop, $20,000. And now I can take the funds back out of the Nevada trust. Sounds pretty smarmy, but it works. You can defraud your creditors if you have your assets in the Nevada trust. Now, anything outside the Nevada trust, they can go after. Anything outside the Delaware trust, they can go after. But anything in the Nevada trust is protected. Creditor protection. Other notable asset protection states. Here are the three I list, but like I said, they're like another 17. South Dakota is considered one of the best irrevocable trust states for a number of reasons. They have great creditor protection. They also allow dynasty trust of an unlimited amount of time. I believe it's until the heat death of the universe, which, as far as I know, is at least like, something like 1 billion, 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 billion years from now, or some number they say that I can't even figure out, which I think I just showed you. I can't figure it out. And South Dakota doesn't have a state income tax. Any of your investments in a Dakota trust avoid state income taxes, which, by the way, is a great reason to have out of state trust to begin with. You can avoid your state's income taxes as well. Now, South Dakota also says, under state law, that the trust funds cannot be used for your past due child support or alimony. I don't know how they do that. But yeah, if you're kind of a schlub and you don't want to pay your child support and you don't like your ex-spouse, you don't want to pay her or him alimony, what we call in New York maintenance, move all your money to South Dakota Asset Protection Trust. Alaska is great for numerous reasons as well, as is Wyoming. So those are other states, but that's the flavor. Anything you place in an out-of-state trust, it is protected from your creditors. Lastly, offshore trusts. Offshore trusts are legal. You just have to disclose them to the federal government. When I say them, I mean their income and their assets. The purpose of offshore trust is for creditor protection, right? You get strong asset protection countries and jurisdictions. They have laws that make it hard for creditors, first of all, to sue you. And even if they win, number two, they make it hard for them to collect from you. Assets you move to other countries may get different types of extreme creditor protection. Now, you don't send money to these states for tax evasion purposes, right? So if I have $20 million in my name and I move $5 million to one of these offshore trusts, yeah, the IRS can't get at that $5 million in that offshore trust, but I still have $15 million here in the United States, right? They're going to get their pound of flesh. And I don't tell people to evade taxes. I tell them to minimize taxes. Now, you can see if you want, if you decide to try to partake in tax evasion, well, they have 5% of the trust assets for not filing the correct IRS forms to begin with. That's even if you don't make a mistake. You just were lazy, right? You meant to tell the IRS, but you didn't. And then they charge an additional 35% penalty in addition to the income taxes for any distributions if you do not disclose this offshore trust. And then it's 5% of the account balances if you just non-willfully didn't comply. So, I made a mistake and I didn't file tax returns this year. Well, guess what? They can take 5% of the balance. And then if you willfully chose not to comply, they can take half of the assets. Now, again, how are they going to get to a trust that's in Nevis, St. Kitts and Nevis? They're not. But you have that $15 million left here in the United States. So good luck trying to evade taxes as long as you have money here in the United States. They're going to get their pound of flesh, the IRS is. Now, the idea of offshore trusts is not necessarily always to protect the money completely from creditors, but just to exhaust and confound them as well. So the point is to just make it too legally expensive and exhausting, put up so many barriers, your creditors just give up. So these are some of the asset protections that are available for all overseas trusts, or most of them. First of all, it's another country. So they don't recognize creditor claims against you that are made here in the United States, right? I have my assets in another country unless they have a reciprocal treaty with creditors here in the United States, which, let's face it, we're not going to use those countries' offshore trusts, right? They won't recognize a New York judgment against the money you have in your offshore trust. Next, they have short statute of limitations. So here we have 2 years and 4 year fraudulent conveyances. Some countries like the Cook Islands, they may only have a 1 year statute of limitations. So by the time the creditor finally figures out that you have this trust, too late. They're already gone. It's too late. The cause of action can't be brought anymore. How do they even know about the trust? There's high privacy in these countries. Very hard for your creditors here in the United States to figure out, does Dan have money in a Cook Island trust? The Bahamas. Does Dan even go there? Does he have a trust there? How are we supposed to find out? They can't find out. And like we said, there's firewall legislation. There's specific laws here that say they'll ignore court orders, not just a lien that's perfected in a court. If a court sends, the Bahamas an order that says you must pay here in the United States, send a check over trust company to the United States for this creditor. The Bahamas just has legislation that says, no, we're not going to do it. We're not allowed to do it under the law. Now, this is how an offshore trust works. Example. So Dan sets up a trust in the Cook Islands with a local trustee in the Cook Islands, and I fund the trust with $5 million. Now, I proceed to get into a slew of accidents and willful misconduct, right? I drive my car into the Steuben Crystal showroom and I cause $2 million worth of damage, right? Because it's crystal, it's going to break, right? Especially when I drive a car through their showroom. I then get into a fist fight with someone, I break their arm, and they win a judgment against me for $1 million. So they're really messed up their arm. And then I steal my favorite car, a McLaren Roadster. It's one of a kind. And then I get into an accident and I destroy the car on Park Avenue. Now, if all of my money is in the Cook Islands, the creditors will try to bring a lawsuit, each of them in the Cook Islands. They'll try here in the United States, first of all. I don't have any money in the United States. So somehow they're going to try to figure out where I have money. Well, they bring a lawsuit. They figure out because I brag about my Cook Islands trust because I'm dumb. They say, all right, well, let's bring a law in the Cook Islands. Well, first of all, they're not going to allow in the Cook Islands any of my claims here or any of their claims made here in the United States. They got to bring a case here in the Cook Islands. Well, the trustee there also has laws in the Cook Islands that confound them. So even if I do lose in the Cook Islands, there's still strong asset protection there. So the creditors are exhausted, right? They tried the US, they lost. Now, after doing all this research, they find out I have $5 million in the Cook Islands. They bring a lawsuit in the Cook Islands, only to find out it's incredibly hard for them to even win. And if they win, I still have creditor protection laws there. The point of this is just to exhaust the hell out of creditors. Eventually, I might want money back in the United States. I have $4 million of claims. My job is to bring them down to $1,000, right? Or else they tell you what, I'll pay you of the $4 million out there creditors, I'll pay between all of you, let's say 500,000. It's better than nothing, right? And they say, fine, we take it. I get to bring back my $4.5 million from the Cook Islands in that hypothetical. Pretty good. Now, this is what the design of these offshore trusts will look like. They're always going to be irrevocable trusts. However, you're going to need a bank or trust company in the offshore location. Remember, we're trying to pay money to these small little countries, that have white collar individuals living there. We want to give money to these countries, and these countries want to give it to these high paid professionals. The trust protector will be someone who can fire these trust companies and get a new one. So you're going to want a friend, or in some cases, a trusted service provider. You can get trust protectors from overseas. Sometimes states like Delaware has professional trust protectors. Plenty of states do. Heck, I'll be a trust protector. You're going to want to have a trust protector that has the power to fire and hire a new trustee in case your offshore trustee is screwing around, not doing what you want. The beneficiary is going to be you and or certain family members, right? Because you want to make sure the funds are going back to yours truly. And last but not least, property owned by the trust. Well, if it's overseas, like we said, New York property isn't going to be able to be owned by this trust, right? Your property, your real estate here in the United States cannot be owned by these offshore trusts. But investments are fine. Bank accounts are fine. Business interests, you may be able to double protect your business and real estate that is in that location, right? So your investments in these offshore trusts are primarily going to be investments. Now, these are the premier offshore locations for trusts. Now, these are just the top 4. Again, there are a bunch out there, but when people are talking about doing business with offshore trusts, it's going to be in these 4 countries, right? First of all is the Cook Islands. I bring them up because they're robust. We call them battle tested because there have been plenty of lawsuits in the United States and the Cook Islands regarding asset protection. It allows immediate trust protection. Like we said, they have a short-term statute of limitations. If my creditors in the United States even find out that I have a trust in the Cook Islands, they have a very short time to bring a lawsuit after it actually happened. It may be too late. We're just trying to frustrate and exhaust them. And the Cook Islands does not recognize foreign court judgments. Well, the Cook Islands are a little far. They're in the middle of who knows what Pacific Ocean. Nevis. St. Kitts and Nevis. Nevis is just around the corner, right? You could take a plane to the Caribbean. Exact same thing. Excellent creditor protection and short statute of limitations, right? High court barriers. It's almost as though Nevis said, we're here just to be your asset protection country, right? So keep that in mind. Next, Belize. Beautiful in Belize. Same thing, cost effective. You can establish a trust quickly in Belize. Hey, they speak English. They speak English in the Cook Islands. You know what? Nevis, they speak English too. But my point is this, right? Belize, beautiful, not all the way in the middle of the Pacific. And last but not least, the Cayman Islands and the Bahamas. That's right. The Cayman Islands also and the Bahamas also allow offshore trust protections. The Cayman Islands specializes in high net worth too. I'm not saying the Cook Islands doesn't, but they have a good reputation. If you want offshore protection from your creditors, which is the premier type of creditor protection that you can get for your assets, unless there's an exemption that's allowed here in the United States, these are the countries you're going to look for. And you're going to want to speak to me, Nacy, and Whitney, because we are the ones that can help you with your asset protection trusts. I want to thank everybody. We ran over, but it was worth it because you're worth it. I'll see you next time on another webinar. This is Daniel Timins. I'll talk to you later.